या होणाऱ्या परीक्षेबाबत आज आपल्याला ॲडव्होकेट अजित कुलकर्णी सर हे इंडियन कॉन्ट्रॅक्ट ऍक्ट ह्या विषयावर मार्गदर्शन करणार आहे। आपले आजचे वक्ते व मार्गदर्शक थोड्याच वेळात इथं उपस्थित राहणार आहे, ऑलरेडी उपस्थित आहेत। आपण थोड्याच वेळात कार्यक्रमाची सुरुवात करूया। तरी मी सर्व वकील बंधू भगिनींना विनंती करतो की आपण बाहेर उभं न राहता आतमध्ये समोरील स्टेजच्या समोरील बाजूस स्थानापन्न व्हावे। एक थोड्याच वेळात आपण कार्यक्रमाची सुरुवात करत आहोत। धन्यवाद।
सर्वांनी स्थानापन्न व्हावं। कोर्च मध्ये थांबलेले जे विद्यार्थी आहेत त्यांनी सुद्धा अशोक हॉल मध्ये येऊन स्थानापन्न व्हावं। थोड्याच वेळात लेक्चर सुरू होत आहे। जे पाठीमागे बसलेले विद्यार्थी आहेत त्यांनी पुढे यावे। पाठीमागे बसलेले जे विद्यार्थी आहेत, पासलकर साहेब या पुढे।
हॅलो, मी मागे बसलेले सर्व वकील बंधूंना विनंती करतो की आपण पुढे येऊन स्थानापन्न व्हावे। आपले आजचे वक्ते मार्गदर्शक इथे उपस्थित झालेले आहेत। आपण एक 5 मिनिटात लेक्चरला सुरुवात करत आहोत। बाहेरील पोर्च मध्ये उभे असणारे वकील बंधूंना विनंती आहे की आपण आतमध्ये येऊन स्थानापन्न व्हावे। पुणे बार असोसिएशन आयोजित व्याख्यानमाला आता जिल्हा न्यायाधीश आणि दिवाणी न्यायाधीश कस्तर व प्रथम वर्ग न्यायाधिकारी या होणाऱ्या परीक्षेबाबत आज आपल्याला मार्गदर्शक म्हणून लाभलेले ॲडव्होकेट अजित कुलकर्णी सर हे आपल्याला इंडियन कॉन्ट्रॅक्ट ऍक्ट 1872 या विषयावरती मार्गदर्शन करणार आहेत। तरी मी सर्व विद्यार्थ्यांना वकील वर्गाला विनंती करतो की आपण लवकरात लवकर येऊन स्थानापन्न व्हावे. हॅलो, कार्यक्रमात आहे अशोक हॉलला. 10 मिनिटात करू का? अँकरिंग करतोय, अँकरिंग. येस येस, चालू का? हॅलो, चालू थोड्याच वेळात सुरू होते. हॅलो हॅलो, सन्माननीय ॲडव्होकेट अजित कुलकर्णी सर यांचं मी पुणे बार असोसिएशनच्या वतीने सहर्ष स्वागत करत आहे आणि येऊ घातलेल्या अतिरिक्त जिल्हा न्यायाधीश आणि दिवाणी न्यायाधीश स्तर व प्रथम वर्ग न्यायदंडाधिकारी या होणाऱ्या परीक्षेबाबत आज अजित सर आपल्याला इंडियन कॉन्ट्रॅक्ट ऍक्ट या विषयावरती मार्गदर्शन करणार आहेत. कार्यक्रम सुरू करण्या अगोदर मी पुणे बारचे उपाध्यक्ष प्रतापराव मोरे सर यांना विनंती करतो की त्यांनी आजचे आपले प्रमुख वक्ते ॲडव्होकेट अजित कुलकर्णी सर यांच्याबद्दल बारला एक परिचय करून द्यावा. धन्यवाद.
आज आपल्याला लाभलेले मार्गदर्शक अजित कुलकर्णी सर यांना आपण नेहमीच कोर्टामध्ये दिवाणी कोर्ट असेल, डिस्ट्रिक्ट कोर्ट असेल, तसेच फॅमिली कोर्ट असेल यामध्ये आर्ग्युमेंट करताना, क्रॉस घेताना, फायनल आर्ग्युमेंट करताना पाहिलेला असेल, पण आज आपण त्यांना प्रमुख मार्गदर्शक म्हणून बोलवलेलं आहे. सरांचा अल्पशा परिचय करून द्यायचं झालं तर सर हे इंडियन लॉ सोसायटी एक भारतातली नामांकित सोसायटी असून, संस्था असून त्यामध्ये गव्हर्नर काउन्सिल मेंबर आहेत. तसेच सर हे ILS लॉ कॉलेजला प्राध्यापक म्हणून काम पाहतात. सरांचं वैशिष्ट्य म्हणजे सर दिवाणी आणि फौजदारी क्षेत्रामध्ये तसेच फॅमिली मॅटर्समध्ये त्यांचे एक नावलौकिक असून त्यांचा सहकार क्षेत्रामध्ये एक वेगळाच हातखंडा आहे. सरांच्या हातून अनेक न्यायाधीश घडलेले आहेत. तसेच सरांनी अनेक सामाजिक जे बांधिलकीचे विषय आहेत त्यामध्ये सरांनी एक मोफत पद्धतीने मार्गदर्शन केलेले आहे. तसेच सरांच्या हातून अनेक जिल्हा न्यायाधीश घडलेले आहेत आणि आता विद्यमान अध्यक्षही सरांचे ज्युनियर असून तेही आपल्या मुख्य व्याख्याते अजित कुलकर्णी सरांचेही विद्यार्थी आहेत. असे अजित कुलकर्णी सरांचा मी सर्वप्रथम पुणे बार असोसिएशनचे अध्यक्ष राम सर यांना विनंती करतो की त्यांनी सर्वप्रथम त्यांचा सत्कार करावा.
धन्यवाद सर. न्यायाधीश होणे हे केवळ एक करिअर नसून समाजसेवेचे एक अत्यंत प्रतिष्ठेचं माध्यम आहे. मी आजचे आपल्याला लाभलेले वक्ते त्यांचं थोड्याच वेळात त्यांचं आपल्याला मार्गदर्शन चालू होणार आहे. त्या अगोदर मी पुणे बार असोसिएशनचे सन्माननीय अध्यक्ष यांना विनंती करतो की त्यांनी आपले 2 शब्द व्यक्त करून पुढील बारच्या होणाऱ्या कार्यक्रमांबद्दल एक छोटीशी माहिती देऊन कार्यक्रमाची सुरुवात करू.
नमस्कार. दिनांक 10 मे रोजी जिल्हा न्यायाधीशांच्या जवळजवळ 89 जागा आणि आता JFC ज्युडिशियल मॅजिस्ट्रेट फर्स्ट क्लास आणि सिव्हिल जज ज्युनियर डिव्हिजन यांच्या जवळजवळ 286 जागा अशा एकूण दोन्ही एक्झाम निमित्त आपण हा जो कार्यक्रम अरेंज करत आहोत की जे तरुण विद्यार्थी आहेत, जे इच्छुक आहेत, त्या इच्छुक विद्यार्थ्यांना ज्यांना क्लासचं मार्गदर्शन मिळत नाही, पुणे बार असोसिएशन मार्फत आपण ही सिरीज आयोजित करत आहोत. आज आदरणीय कुलकर्णी सर आपल्याला मार्गदर्शन करणार आहेत. उद्या ॲडव्होकेट राजेश कातोरे सर फौजदारी लॉ जे न्यू क्रिमिनल लॉज आहे त्यावरती मार्गदर्शन करणार आहेत. परवा निगोशिएबल इन्स्ट्रुमेंट ॲक्टवरती ॲडव्होकेट धनाजी जाधव सर हे मार्गदर्शन करणार आहेत. आणि गुरुवारी आदरणीय गुंजीकर सर CPC दिवाणी प्रक्रिया संहिता यावरती मार्गदर्शन करणार आहेत. पुणे बार असोसिएशन मधून जास्तीत जास्त वकील मंडळी न्यायाधीश होत याच एका उद्देशाने आपण ही लेक्चर सिरीजचं आयोजन करत आहोत. ॲज फार ॲज कुलकर्णी सर जे आहेत, मी जे लहानाचा मोठा झालोय तर जी काही जडणघडण आहे त्या जडणघडणीमध्ये जन्मापासून, माझ्या वकिलीतल्या जन्मापासून ते आत्तापर्यंत जो सर्वात मोठा वाटा आहे तो सरांचा आहे. सरांच्या विषयी काही 2-3 गोष्टी सांगतो. सरांचा पर्टिक्युलरपणा हा खरंच वाखाणण्याजोगा आहे. नीटनेटकं राहणं, ज्यावेळेस आपण नीटनेटकं राहणं असं म्हणतो वकिली क्षेत्रामध्ये, जरी तुमची गरिबी असली, सर पण गरिबीतून आलेले आहेत, मी पण गरिबीतून आलेलो आहे, जरी तुमची गरिबी असली तरी एक आपला साधा पांढरा शर्ट, जरी त्याला इस्त्री नसली तरी पांढरा शर्ट संध्याकाळी स्वच्छ धुवायचा, तो दुसऱ्या दिवशी तो शर्ट घालायचा. शूजला पॉलिश जरी नसलं तरी एक कापडाचा बोळा, त्याने तो आपला शूज जो आहे तो स्वच्छ पुसायचा. ही सरांची नित्य नियमावली होती. सरांनी अत्यंत खडतर परिस्थितीतून आज हे वैभव उभं केलेलं आहे. आणि सर नुसते स्वतः उभे राहिले नाहीत, तर सरांनी माझ्यासारखे अनेक विद्यार्थी घडवलेले आहेत. न्यायाधीश असू दे, उच्च न्यायालयात असू दे, सरांचे विद्यार्थी आजही काम करतायत किंवा न्यायदानाचं काम करतायत. सर, एक वाक्य आहे की बिल्ड युअर सेल्फ सो ॲज टू बिल्ड अदर्स, की तुम्ही स्वतःला इतकं मजबूत करा की जेणेकरून तुम्ही दुसऱ्यांना मजबूत करू शकाल. तर सरांनी हा वारसा आमच्याकडे सोपवलेला आहे आणि एक फुलाची पाकळी या स्वरूपामध्ये तो वारसा आम्ही पुढे चालवत आहोत. न्यायदानाचं जे कार्य आहे, तर इथे दिक्कतवार साहेब होते, त्यांच्या म्हणण्यानुसार हे न्यायदानाचं कार्य जे आहे ते विष्णूचं कार्य आहे आणि हे विष्णूचं महत् कार्य ज्यावेळेस आपण करणार आहात न्यायाधीश या पदावर गेल्यानंतर, तर खरंच समाजाची एक वेगळी सेवा आपल्या हातून घडणार आहे. तर या समाजरूपी सेवेमध्ये कुठेतरी एक पुणे बार असोसिएशन कॉन्ट्रीब्यूट करू इच्छित होतं, म्हणून ही लेक्चर सिरीज आयोजित केलेली आहे. तर आपण आणि आपले विद्यार्थी वर्ग या सगळ्यांनी याचा लाभ घ्यावा अशी मी विनंती करतो. आणि जास्त वेळ न दवडता मी कुलकर्णी सरांना विनंती करतो की आपण त्यांनी मार्गदर्शन करावं. धन्यवाद.
Dear friends, good afternoon. Today's topic is Indian Contract Act. It's a huge subject. I'll try to manage it in an hour's time, and obviously because of the time constraint, I'll be going a little fast. Contract and agreement, these are the two terminologies that are used by lawyers, and there is a difference between an agreement and a contract. For contract you require two parties. There are some other documents also which are executed by a single person and they have a legal validity. For example, indemnity bond or a declaration, or it is also called as a deed poll, wherein single person will declare something, write something, or even a will is written by one person. There is no other party required for all such documents, and these are all legal documents. As far as contract is concerned, essentially there are two parties which are required. Now, a contract may be between two parties in the sense that first party may consist of multiple parties and the other party may consist of multiple parties. So there can be any combination. It starts with offer. Now, offer is given by one person. He signifies his offer to the other person. He communicates his offer to the other person with an object of obtaining assent of the other person. So the object of making an offer is to obtain assent, meaning thereby consent of the other person. So it may so happen that the offer is given and the other person may not respond. Then in that case, offer remains as an offer and the matter does not go beyond. But when the other person responds, it is exactly what is called as acceptance. So when it comes to offer, the person making an offer is called as an offerer or a proposer, and the person to whom the offer is made is called as the offeree or the proposee. So this is between the offerer and the offeree that the offer and the acceptance takes place. Offer must be communicated to the other party. Is the essence of contract. Unless until it is communicated, your intention is communicated to the other party, that cannot be a valid offer. Now, offer might be express or implied. meaning thereby express is words, written or oral, and implied is by actions, acts and actions. So intention is most important. Intention must be to get an acceptance from the other person when you are making an offer. Now, the acceptance may be communicated by the other party, meaning that by the offeree, expressly or impliedly. So if at all I say that will you please come for a cup of tea with me in a canteen, this is my offer, and the other person says that yes, I'll come. So this is acceptance which is express. However, I say that you, those who are interested in this hall, may join me for a cup of tea in the canteen, and no one says anything, but 5 or 10 people, advocates, friends of mine, they follow me and we join there in a canteen. So this is not expressly communicated to me that yes, I'll join you for a cup of tea, but your act and action clearly shows that you have accepted my offer. So the acceptance may be either oral or written, or it may be in the form of, rather it might be passive, meaning that my act and action can be regarded as acceptance. Now, an offer, whenever is given, must be communicated to the other party. When it is communicated, you are entitled to revoke the offer before it reaches to the offeree. You have posted it in the post, your rather proposal, that this is my proposal, and then you change your mind and you say that this is not the offer, I should withdraw this offer. So by email or by fax, you, by faster communication, you communicate to the other party that whatever you will receive by post was my offer. However, this is not my offer and I am revoking it, I am cancelling it. So the offer once given can be cancelled, it can be revoked, provided that it reaches the other party. When it reaches the other party, the offeree, you cannot rescind the offer, you cannot cancel the offer. Similar the case with the acceptance. The other party must communicate the acceptance to the other party. Now, acceptance, mind well, must be unconditional. If at all there is a condition that yes, I am ready to do this, however, if you will do this. So, if you will do this is a condition. And when it is a conditional acceptance, it is not an acceptance in the eyes of law. A conditional acceptance always is regarded as a counter proposal. Because I am saying that will you please buy this jacket for 1000 rupees. You are saying that will you please give it to me for 800 rupees. This is a counter offer and not acceptance of my proposal. So that may be a counter offer and it is up to me whether to accept it for 800 rupees or negotiate further or not. Now, offer once accepted by the acceptor becomes a promise. So when the offer is made with an object of obtaining assent of the other person and the other person accepts the offer, it becomes a promise. And an agreement is nothing but a promise, single promise or set of promises. So agreement consists of many promises or even a single promise. A single promise is that will you please go and attend my Bombay High Court matter tomorrow. If at all I give you the offer, you said yes, and you go to Bombay and conduct matter on my behalf. This is a single promise. So the remuneration, all these things, considerations will be considered at a later point of time. What is important is the agreement may consist of a single promise or it may consist of set of promises. Now, acceptance must be therefore absolute and there should not be a counter proposal involved in it. Now, what is a contract? What is an agreement and what is a contract? Now, there are certain social engagements wherein there is the offer and there is acceptance. Will you please join me for a social gathering on coming Sunday at 5 o'clock? We will have some discussion and then dinner. This is a social offer. There is no legal binding on it. You accept, and on the accepted day, you do not turn up there. You don't come to me. In that case, whether this is a breach of contract, yes, this is a breach of agreement and not a contract. This is a breach of promise that I'll come and you don't come. It's a breach of promise. I cannot sue you for that. That you did not attend my function on that day and therefore I am suing you in the court of law. Is not a case. And therefore the difference between the social offers and acceptance and the agreement or contract is that there must be a legal binding. There must be a legal binding between the proposer and the acceptor, to make it a contract. So all offers and promises that are made are agreements. They are agreements, there is no doubt, because there is a offer, there is a acceptance. Once the offer is accepted, it becomes a promise, and once it is a promise, it is an agreement. It is an agreement, but it may not be legally enforceable agreement. And therefore, to make it legally enforceable agreement, there are certain important legal things that are required to be followed. And first is, you must be competent to enter into a contract. Competency of the parties is most important. As far as competency is concerned, first is that you must be a major person. A minor cannot enter into an agreement. Minor's agreement is void ab initio. It is not an agreement in the eyes of law. Secondly, a person must be of sound mind. And third important point is that person should not be prohibited by law from contracting. Meaning thereby certain laws say that if at all you have done this, then in that case you are prohibited from executing a contract. And a classic example of that is that insolvency matter. If at all you have been declared as insolvent by a competent court, then you are not at all entitled to enter into any valid contract. So there is a disability. This is legal disability as far as execution or signing of an agreement or a contract is concerned. So the first is there must be competency. Second is there must be free consent. Next is lawful object. Next is lawful consideration, and the agreement itself should not be barred by law. So these are the 5-6 essential conditions to make it an agreement. So there must be a legal binding as far as the agreement to convert into a contract is concerned. In a contract, both the parties are legally bound to do that. Now, first is competency. As I have said, the person should not be disqualified from entering into contract. If all he is disqualified from entering into a contract, then in that case, you are not entitled to make an agreement. Such kind of a disqualification you will find in many other places as well. Such kind of a disqualification is in case of a son who murders his father with an object of inheriting his property. Such son is disqualified from inheritance. Such kind of legal disqualifications are there in various laws. So the object of that particular murder must be to inherit the property. With that object, if it is established, then in that case, that son is not entitled to inherit the property of the deceased father. Second is free consent. First is competency, second is free consent. Free consent has again 5 elements. The consent ought not to have been obtained by threatening to commit any act prohibited by IPC. Previously it was IPC. So threatening to commit, meaning that I will kill you if at all you don't sign, is coercion. You are forcing the other person. You are threatening the other person to do commit an act which is prohibited by law. And by that particular force, you are asking him to sign. That signature or that consent is not a valid consent in the eyes of law. Then is undue influence. Undue influence is a typical relationship between two persons, wherein one person is able to dominate the will of the other person. Like a son and the father. If at all the father tells him, his 21-year-old son, that please sign it here. And the father is 68 years old, for example, please sign here. The son has absolute trust in the father and he signs it blindly. This is undue influence. After all, the father is taking something wrongly written in that particular agreement. Similar is the case with guru and the disciple. Similar is the case with income tax officer and the SSC. So if at all one person is able to dominate the will of the other person and obtain his consent for an agreement, such a consent is not a valid consent in the eyes of law. Third is fraud. In case of fraud, before fraud I'll take misrepresentation. Now misrepresentation is a positive assertion of a particular fact which he knows to be false. So I am making a statement, positive assertion, that this is the case, but I know that this is false, the statement is false, is misrepresentation. Now the distinction between misrepresentation and fraud is very simple, and that I'll come to it at a later point of time. In case of misrepresentation, mind well, the other person may not cause any injury or loss. For example, I am Ajit Kulkarni, I am before you, and while I am introducing myself to be Ajita Joshi. This is misrepresentation. However, I am not causing any injury to you. I am not causing any harm to you. And therefore, this is simple misrepresentation. So, simple misrepresentation is, in Marathi, we call it as खोटं बोलणं. पण खोटं बोलण्यामध्ये सुद्धा आणि थाप लावण्यामध्ये फरक आहे. खोटं बोलणं ज्याच्यातनं दुसऱ्याला इंजुरी होऊ शकते. थाप लावण्याने इंजुरी नाही होत. तर त्यामुळे थाप आणि खोटं याच्यात जो फरक आहे, तर मिसरिप्रेझेंटेशन is a simple assertion wherein you know that the fact is false, and in spite of that you are going ahead and telling this. Now in some cases it may so happen that I am making a statement but I am not aware about the truth of that particular statement, whether it has happened or not happened, I am not aware, but still I am making a representation. Such representation, if at all on the basis of this representation the other person is induced to enter into a contract, such contract, the consent thereof is not at all valid. On that ground, the contract can be avoided. Next is fraud. In case of fraud, in case of misrepresentation, there is only a simple false statement. In case of fraud, you have intention to deceive the other person from the very beginning. From the inception, you have an intention to deceive the other person. So with that fraudulent object, you make some statements and then induce the other person to execute a contract. That consent is not a valid consent. Now, there are various facets to this fraud, whether silence amounts to fraud when the duty to speak arises. For example, there is an example which says that I am selling a horse and I know that the horse is of unsound mind, and you come and buy that horse because it is for sale. This is not fraud, because you did not ask me any question and therefore I did not say anything. This is a horse for sale, but the horse is of unsound mind. But if you ask me a question whether the horse is all right, whether there is any defect in the horse, and if I keep quiet, then that is fraud, because I know that the horse is of unsound mind. In spite of that, I am keeping quiet. Duty to speak arises when the other person puts certain questions. So simple silence may not amount to fraud, but silence may amount to fraud. In some cases, it depends upon facts and circumstances of each case. Now, third one or the fourth one is mistake. Mistake as to the fact and mistake as to law. As far as mistake is concerned, mistake of fact is simple example that I always say is that I am selling a flat at Deccan Gymkhana to her, and I have intention that will you please buy that flat of mine for 1 crore. She says yes. She has my flat at Kothur in her mind. So she says under the impression that she is purchasing Kothur flat, and I am under the impression that she is buying my Deccan Gymkhana flat. So there is a mistake as to the subject matter of the contract, and that mistake must be in the mind of both the contracting parties. That will render the contract void. If at all there is a mistake of fact, something different in my mind and something different in the other's mind, that renders the contract void. Mistake of law is not an excuse. We have been taught this in the first LLB. Mistake of law is not an excuse. So mistake of law cannot be rather regarded as a mistake within the meaning of this section. However, mistake of foreign law is as good as mistake of fact. For example, I am selling particular goods to a buyer in London. I am under the impression that the sales tax over there is 4%, and in fact it is 18%. And he is under the impression that whatever I am selling, the GST here is something 5%, and it is in actuality it is 18%. So there is a mistake about foreign law in his mind and my mind. Under that impression, if at all I have executed a contract, mistake of foreign law is as good as it is equal to mistake of fact. So on that basis, the contract can be avoided. So on all these things, if at all there is a coercion, there is undue influence, there is a fraud, there is a misrepresentation, or there is a mistake, the contract can be avoided. Now whether these contracts are void, the answer is no. I have obtained your consent by misrepresentation. You have executed a contract, you have signed it, and then subsequently you realize that okay, I have signed it, but I'll continue with the contract because no harm is caused to me. In that case, both of us may continue with the contract and both of us may perform our respective promises in spite of the fact that your consent was not a free one. So the choice has been given always to the aggrieved party. Aggrieved party meaning that the person who is at a disadvantageous position is at a liberty to cancel the agreement, to make it void, he has to go to the court and say that one of the things that have been mentioned in the Indian Contract Act have been employed, and therefore I am not at all bound by this contract. My consent was not a free one. And in that case, the court shall declare that particular contract to be void contracts. So these contracts are void contracts. These are not void. These are voidable contracts. These are not void. So there are three categories of contracts under the Indian Contract Act. First is a valid contract, which is executed according to law. Everything, consent of the parties is free. Parties are competent to enter into contract. The parties are not under mistake anything. So knowingly, both the parties are executing the contract. This is exactly what is called as valid contract. As far as valid contract is concerned, both the parties are bound by that contract. Second is voidable. If at all your consent is not valid because of the 5 reasons that I have just mentioned, then in that case it can be avoided. So voidable contract is always avoidable, mind well. Voidable is always avoidable at the instance of the aggrieved party. It is the choice of the aggrieved party whether to continue with the contract or discontinue with the contract. And the third category is void agreement. These are called as void agreements because they are not converted into a contract. An agreement is converted into a contract when there is a legal binding. For example, if at all I have executed a contract with a minor, it is not a contract, it remains an agreement because an agreement with a minor is void. So to make a contract, make an agreement into a contract, all legal requirements must be followed, they must be there, they must be present in each and every agreement. So void agreements are declared to be void under the Indian Contract Act. So these are not at all agreements in the eyes of law. An agreement without consideration is void. What is consideration? Consideration ला मराठीत आपण मोबदला म्हणतो. Consideration is compensation. Consideration is compensation given by one party to the other for performance of the promise. Now the consideration may not be, mind well, consideration may not be in the form of money, or it may not be in the form of any value. Consideration may form a promise even. If you will not go to Mumbai tomorrow, I will not go to Delhi the day after tomorrow. So these are promises. This is a valid contract because you are rather I am asking you not to do this particular thing, and for that I will not reciprocately, I will not do this particular thing. So even a promise constitutes a consideration. As far as consideration concerned, past consideration is valid consideration, meaning thereby any act which has been done in the past, and on the basis of that particular act, because this is not done at the desire of the promiser. I am the promiser, so the act is already done. For example, A has saved B from drowning. In that case, subsequently, A may or B may declare that I will pay you 5 lakh rupees by way of award because you have saved my life. So this is a past act which is already done. So the agreement, rather consideration, may be past consideration. It may be present consideration. I am buying this particular mobile from you. I am paying you 1 lakh rupees. You are giving me this mobile. So this is present consideration. And future consideration is that you pay me this much now. I'll pay you after 6 months this much. After 1 year this much. So this is to be performed in future. So the consideration may be past consideration, present consideration, or future consideration. All these considerations are valid in the eyes of law. In England, according to British law, past consideration is no consideration. You have to have essentially present consideration or future consideration. An agreement without consideration is rendered void. Another important aspect of consideration is that consideration must flow from both the sides. Consideration must flow from both the sides. I am paying you 1 lakh rupees and you are giving me this mobile. So this mobile is consideration for me. 1 lakh rupees is consideration for you. Even I say that if at all you do this, I will do that. My promise to you, and in return your promise to me. Promises constitute consideration. So consideration must flow from both the sides is the essential requirement of valid consideration. Now the object of consideration must be also valid, and the consideration itself must be lawful. For example, if at all I am engaged in bribery and I have said that I'll pay that particular city engineer 1 lakh rupees for getting my plan sanctioned from PMC. In that case, the consideration as well as the object both are invalid and bad in law, because I am paying him that particular 1 lakh rupees by way of bribery. This consideration is no consideration at all. Such kind of a consideration, the object of law, the consideration must have a lawful object. So if at all the object of your consideration is unlawful and the it is without any, rather it is on the based on illegal object, then in that case such kind of a consideration is not a valid consideration in the eyes of law. So consideration is most important. It must flow from both the sides, and the object must be valid, and the consideration itself must be legal. An agreement without consideration is void ab initio. The exception to the rule is that gift. In case of gift, I am giving a gift to my wife out of natural love and affection. She accepts it. Then in that case, there is no consideration. So probably love and natural love and affection is the consideration for that, but no monetary consideration involved in that. So gift is an exception to the rule that an agreement without consideration is void. Any agreement in restraint of marriage is declared to be void. Now this restraint, this prohibition must be throughout the life. For example, if I tell him that you will not marry for next 3 years and he agrees and there is an agreement to that effect, and in that case I am saying that I will give you this and I will give that. This kind of a restraint is a partial restraint. For 3 years you are not supposed to marry. Thereafter you are supposed to marry. Or if at all I say that you are not supposed to marry this particular girl, this is a partial restraint and not a complete restraint. This is also valid, because I am saying that marrying this girl, you marry any girl, but not this girl. Or you don't marry for next 1 year. And there are some service contracts. There are some contracts wherein the employer may say that you are not supposed to marry till you attain the age of 25 years. There was such kind of a employment contract between Air India and the air hostesses, and that went to the Supreme Court, and there is a famous case on that, and the Supreme Court says that this is an agreement in restraint of trade, not trade, this is an agreement in restraint of marriage, and therefore this is invalid, and therefore the Supreme Court removed that particular condition. So agreement in restraint of marriage is invalid. Likewise, agreement in restraint of trade is invalid. Now, as far as trade is concerned, again, there might be a partial restraint. If at all I am buying patent from him, then that is, while buying patent from him, I may say that you are not supposed to carry out similar business for next 15 years. That particular restraint is perfectly valid. Understand? So there are exceptions to the rule, or there might be trade combinations. We are all plastic pen manufacturing persons or manufacturers. We come together and we say that each and every of us will sell the pen at a minimum cost of rupees 20. Below 20, no one will sell the pen that we are manufacturing. So these are called as trade combinations. Or in case of partnership firm, if at all we are partners, you are retiring from the partnership firm, I may put a restriction that for next 5 years you are not supposed to engage similar business which will compete my partnership business. So there are some restrictions. These restrictions must be reasonable, and these restrictions must be for a small period, little period, and these are partial restrictions. Partial restrictions are allowed. Complete restrictions is illegal and bad in law. Then an agreement in restraint of legal proceedings is again void. That we execute an agreement, we say that you will not go against me in a court of law. That is, the agreement in itself is bad in law. However, the exception to the rule is that arbitration. If at all we say that in an agreement itself, we say that instead of going to the court, we will go to the arbitrator, and the arbitrator's decision will be final and binding. In that case, that agreement is valid, because we are restraining ourselves from going to the court, but we are allowing that particular facility of approaching the arbitrator. Now, the arbitrator again may be appointed in respect of future disputes that may arise, or existing dispute. That this is the existing dispute, we want to refer it to the arbitrator. So arbitrator may be appointed for existing dispute as well as future disputes. Both is legal, and this is not in restraint of legal proceedings. Then uncertain agreements are void. Meaning of the agreement cannot be ascertained. In that case, the agreement is void ab initio. For example, I agree with you that I shall sell you 100 tons of oil. Which oil is supposed to be sold? Which oil is supposed to be delivered is not mentioned, only 100 tons. This is ambiguous agreement. Such ambiguous agreement is not tenable at law. It can be avoided because it is not avoided, it is void ab initio. Recently, we have won a very complicated case in civil law wherein the agreement was found to be uncertain because the terms and conditions were not certain. So it depends upon the terms and conditions. Therefore, while drafting a contract, you have to see that all terms and conditions are very specific, they are categoric, and everything is meaningful. That is your responsibility as a lawyer while drafting a contract. Now, wagering agreements are void. Wagering meaning they are betting agreements. Betting is prohibited. Only exception is horse race. Now, why it has been kept exception, I don't know. But this law has been made by Britishers, and the Britishers, they used to indulge in horse racing, and therefore they have kept horse racing as an exception to the rule that wagering or betting contract agreements are void ab initio. Next is an agreement to do impossible act is void. So impossible act meaning that if at all you climb 10-story building in 1 minute, I'll pay you 1 lakh rupees. It is an agreement to do impossible act, and therefore such an agreement is void again. So there are such 7 or 8 different kinds of agreements which have been declared to be void ab initio. These are not agreements in the eyes of law, and therefore the title, if at all you go to say, the title of the chapter is void agreements. The chapter does not say void contract, because they have not been converted into contract. From an agreement, they remain agreement even though you execute that. Next is contingent contract. Contingent contract is a contract whereby one party agrees with the other party to do or not to do something depending upon happening or non-happening of future uncertain event. So to do, I will do this if at all this does not happen. I will do this if this will happen. And I will not do this if this happens. I will not do this if this will not happen. So there are 4 combinations in this. An agreement whereby you agree that I will do or not to do something if this happens or does not happen. So these are the 4 combinations mentioned in the contingent contract. Now contingent contracts are perfectly valid contracts. For example, a classic example of contingent agreement is a insurance contract. Fire insurance. If at all I am buying this particular mobile, theft insurance, I insure this mobile. If at all the mobile is stolen, I am entitled to get 1 lakh rupees. So this is contingent contract, happening or non-happening of future uncertain event. So if at all it is stolen, I am entitled to get. If at all it is not stolen, there is no question of performance on the part of the insurance company. However, all life insurance contracts are not contingent contract. Why? Because your death is certain. Since death is certain, life insurance contracts are not contingent contracts. You may die tomorrow, you may die after 5 years, or you may die after 25 years, but death is certain, and therefore it is not contingent contract. Essential ingredient of contingent contract is that the happening or non-happening of future uncertain event. If at all Sachin Tendulkar will hit a century today, I will pay you 100 rupees. This is a contingent contract, but this is a wagering contract as well, and therefore this is void. But this is contingent contract. Understood? So if all this happens, Mamata Banerjee, if all today loses the election, I will pay you 100 rupees. This is a contingent contract. However, this is void because this is a betting contract. So happening or non-happening of future uncertain event, this contract is the performance of that depends upon the happening or non-happening of future uncertain event. Now, the event that you are contemplating must take place. This is also another essential. An event which you know is not at all going to take place cannot form a part and parcel of the contingent contract. The event, the contemplated event must take place. Either it must take place or it may not take place, but the contingency must be there. For example, if at all I say that execute an agreement with you in respect of a person who is no more on this earth. If at all ABC, who is dead, will do this. So this agreement is not at all an agreement. Therefore, the event must take place or it may not take place should be the position while entering into an agreement. Now, when you are supposed to perform this particular agreement, because happening and non-happening of future uncertain event, you have to perform when the future uncertain events happens. So when it happens, you have to perform. And you are not, or you are supposed to perform when it is now clear that the future uncertain event will not take place at all. For example, if at all I'll give an example of Sachin Tendulkar again. If Sachin Tendulkar hits a century, I'll pay you 100 rupees. Sachin Tendulkar is out on 5. So it is not going to happen. So that in that case, you are supposed to perform. So happening of that particular event when it takes place or non-happening becomes absolutely clear that this particular thing is not going to happen. Then in that case, you are supposed to perform. Now, third category might be the event may become impossible to perform. Event may become impossible to perform. In that case also, you are supposed to perform because happening or non-happening, the event is not going to perform. Now, therefore, you are supposed to perform. So, contingent contract has to depend upon future uncertain event. All the essentials of valid contract must exist in contingent contract, and then and only the performance of that particular contract depends upon happening or non-happening of that particular event. Now, when we are supposed to perform the contract, this is most important. The person, I have already said that a contract on an agreement is nothing but promise or set of promises. So when it is set of promises, you have to offer to perform. For example, if at all I have said that I'll supply you 100 mobile sets. This is a contract between us. On such and such date, 100 mobile sets will be supplied to you. There must be offer to perform from my side. So it is my duty to call her up and ask her when should I send 100 mobiles as per our agreement. So this is exactly what is called as offer to perform. So I am ready and willing to perform my part of the contract that must be communicated to the other party. Agreement is executed, 100 mobiles I have procured. Now is the time for delivery. So I have to tender my performance. This is exactly what is called as tender of performance. Now I have offered her to perform and she does not respond. For last 1 week, I have been contacting her daily and she is not responding. This clearly shows that she has refused to accept my performance. If at all she has refused to accept my performance, she has committed breach of contract. Because readiness and willingness I have shown, I have tendered my performance, but she has refused to accept that performance of the agreement. And therefore, this particular performance, if at all is not accepted, becomes a breach of contract. Now, this particular offer as well as the acceptance thereof, offer to perform and the acceptance, performance should be accepted, both should be unconditional. If at all there is a condition that it has been decided I'll pay you, I'll deliver you 100 mobiles and 1 lakh is the cost of each mobile phone. Then I put a condition while delivering, unless you pay me 50% advance, I will not deliver a single mobile phone to you. Then in that case, this is amendment, unilateral amendment, this is conditional performance. This conditional performance is not a valid performance in the eyes of law. So the performance must be unconditional. The performance must be made at a proper time. At 12 o'clock at night, if at all I call her up and say that, shall I deliver 100 mobiles to you now? This is not a proper time. Proper time is usual business hours. If at all between 10 and 5, there is a communication. Proper place. So her business place, my business place, that must be offered at a proper time, proper place, by a proper person, by an authorized person. That particular offer must be by an authorized person. So all these things must be must be followed. Whatever has been mentioned in the agreement, those things must be followed. And in spite of this, if the other person commits breach, refuses to accept the offer, then in that case, he or she commits breach of contract. And that breach of contracts will give rise to a suit for specific performance. Now, at the time of executing the contract, when it comes to performance, there might be some stipulations, meaning thereby I might prescribe certain rather delivery of that particular goods, those goods might be in a prescribed manner. So she may put a condition that each mobile should be wrapped in a gift wrapper. So if all that is the prescribed manner in which I should perform is mentioned. So I have to do it in that manner only. If at all I send her only mobile phones without gift wrapper, then that case that is not a proper performance on my part. So if at all a particular manner has been prescribed in performing that particular contract, that manner has to be followed. For example, if you buy one shirt, the second shirt is free in sale. Buy one shirt, second shirt is, you have to buy my shirt first and then you will get the second shirt. So prescribed manner of performance must be followed. This is most important. Now there are some cases wherein there is a reciprocal promise. Reciprocal promise is a promise performance of which depends upon the performance of the first promise. So there is a promiser and there is a promisee. So the promisee is not supposed to perform his part of the promise unless until the promiser has performed his part of the promise. A classic example of this I will give you is this flat agreement between the builder and the flat purchaser. You are a builder and I am a flat purchaser. You have said that I'll cast first slab and then you pay me 50 lakhs. I'll cast second slab, then you pay me 25 lakhs. I'll cast the third slab in the building, then you pay me remaining 25 lakhs. So this is exactly what is reciprocal promise. So unless until you have casted first slab, I am not supposed to pay you anything. So it takes 3 years for you to cast first slab. I am not supposed to pay anything till 3 years. But if at all you have cast already your first slab is ready, I have to pay you. Then your second slab is ready, I have to pay another installment. Third slab is ready, I have to pay the third installment. So reciprocal promises, first promise has to be performed, then the other party has to perform, then again the first party has to perform, and then the other party has to perform. These are called as reciprocal promises. The other party is not supposed to perform its part of the contract unless until the first party perform his part of the contract. So these are called as reciprocal promises. Now there is a concept called novation. Novation is, there is a doctrine of novation. Novation is the parties may come together. The parties have executed a contract. They are supposed to perform their part of the contract. They come together during the pendency or during the subsistence of the contract and they substitute the original contract with a totally new contract. In that case, the original contract comes to an end. So this is exactly what is called as novation. For novation, both the parties must agree. Unilaterally, if at all I have made some changes in the agreement, that is not novation, that is unlawful alteration, that is forgery. Without asking the other party, I am making changes in the agreement, that is forgery. Second is, the parties may come together and alter part of it. That clause number 9 should be substituted by this. So the entire agreement is not altered, rescinded, the part of the agreement is altered. And third is that both the parties may come together and say that we will cancel the agreement, but because you are not interested in performance, so we will cancel. So first is substitute the original one, second is alter part of it, and the third one is we rescind or cancel the agreement. So all these things are called as doctrine of novation, and in all these three things, the original contract will come to an end. This has to be done by both the parties. Unilateral act in this regard will not suffice the purpose. Then there is a concept called quasi-contractual liability under the Indian Contract Act, meaning thereby certain relations which are resembling to a contract. There is no contract initially, but subsequently some circumstances take place and now you are supposed to perform as if the parties had executed a contract. So this is exactly what is called as quasi-contractual liability. For example, first is supply of necessities. If at all the minor has been provided with the necessities of his life by me, there is a minor, I am taking care of the minor. On becoming major, I can get reimbursement of all the expenses that I have made during the minority. So supplies of necessaries to a minor or lunatic that can be subsequently reimbursed. Even though there is no contract, he becomes a major and I can sue him that saying that these are expenses made by me on you. You are supposed to compensate for that, and the court shall grant that compensation to me. Second is person interested in making the payment. If at all a person is interested in making the payment and who is not a party to a contract, subsequently such person, if at all makes a payment, is entitled to get it reimbursed. A classic example of that is that you are a landlord and I am your tenant and you have not paid the municipal taxes, and the municipal taxes has sent a notice to you saying that if you fail to pay municipal taxes of 5 lakh rupees, your house will be sealed. I am staying in that. So my house will be stealed, my tenancy will be jeopardized. So I go to the corporation and make the payment of 5 lakhs because I am a person who is interested in making the payment to save my tenancy. In that case, I may sue you later saying that this is your responsibility to pay the corporation. I have done it to save my tenancy. Now you pay me 5 lakh. The court shall grant 5 lakh rupees. She cannot say, why did you pay? Who told you to pay? It cannot be a question. And this is exactly what is called as quasi-contractual liability, wherein there is no contract initially, but subsequently because of the circumstances, the situation is like a contract. So it is called as quasi-contract. Next is non-gratuitous act. If at all I am a supplier of goods or kirana malwala and I have sent her sugar, 5 kgs of sugar. So I have told my servant to go and deliver it to Mr. Deshpande's house. Instead of delivering to Mr. Deshpande, he delivers it to Joshi. And Joshi consumes that particular sugar. In that case, if at all I go and ask Joshi that you pay, please pay, make a payment for 5 kgs of sugar, he cannot say that where was the contract? Did I ask you to deliver 5 kgs of sugar? Because he has consumed it. Otherwise, he ought to have kept that sugar intact. After all, I would have gone to him or her. She ought to have returned that 5 kgs of sugar that this was not ordered by me. Please take it back. If at all I have consumed it, then in that case, a quasi-contractual liability arises to pay for that. So, non-gratuitous act. There is no intention of making any gratuitous act. Gratuitous act म्हणजे चॅरिटेबल ऍक्ट. चॅरिटेबल म्हणजे धर्मादाय एखादी गोष्ट. उदाहरणार्थ मी एखाद्या गरीबाला 5 किलो साखर देऊन टाकली तर त्याच्यात quasi-contractual liability येणार नाही बिकॉज दॅट इज अ ग्रॅटिट्युअस ऍक्ट. धर्मादाय केलेली गोष्ट. पण नॉन ग्रॅटिट्युअस आय एम सप्लायर ऑफ शुगर अँड आय सप्लाइड हिअर शुगर ऑफ 5 kgs. In that case, you are supposed to get reimbursement. Finder of goods. म्हणजे I have found this mobile and for the purpose of preserving it, I have spent certain amount on this. I have spent 5,000 rupees on preserving this. I have kept in a locker in the bank. So I have to pay for the locker charges to the bank. In that case, finder of the goods, if at all has spent any amount on preserving the goods, then in that case, the person who is the owner of those goods is supposed to reimburse that particular expenses made by the finder of the goods, because he cannot say ki, who have told you to spend on this. So this is for the preservation of your own goods that I have spent the money. Now you pay for it. So that is another quasi-contractual liability. This particular relationship is like a bailor and bailey. I am coming to that at a later point of that, but this is like a bailor and bailey. And money paid by mistake or coercion. If at all at a gunpoint I ask him, pay me 5,000 rupees. At a gunpoint, he pays me 5,000 rupees. He is entitled to go and get it reimbursed. Why? Because he can always say that Mr. Kulkarni came at a gunpoint. He has recovered 5,000 rupees from me. I want it back. The court shall, if at all he is able to prove that I had done this, the court is entitled to, the court will grant him compensation of 5 lakh rupees. So coercion or mistake also. So instead of paying him, I have paid him. So it is by mistake that I have paid him the money. I am entitled to go to the court and recover it. He cannot say that now I will not repay that particular money. Now, when it comes to breach of contract, you are entitled to get specific performance. Now, specific performance of the contract is you go to the court and tell the court that as the defendant to perform his part of the promise. For example, I have appointed him as a contractor to construct a bungalow. I have paid him 2 lakh. I have been paying him certain amounts, and in all 50 lakh rupees has been paid by him to construct my bungalow. He is a contractor. He leaves the work in between, halfway. In that case, I am entitled to go to the court and get a specific performance against him that he should be directed to complete the construction of the flat or complete the construction of the entire bungalow. That is exactly what is called as suit for specific performance. Now, you are entitled to get compensation in addition to specific performance. So in a suit for specific performance, you are entitled to get compensation, only compensation, no specific performance. Second is only specific performance, no compensation. And third is combination. I want specific performance and he should be penalized. I should get compensation as well. So both the things can be asked, or at a time one thing can be asked. In that case, what is important is the question may arise as to how much compensation should be granted, because one breach of contract may give rise to multiple promises that are made in future. because if at all I have said that I'll pay you 50 lakh rupees by the end of this month. In further, you tell the other person that I'm getting 50 lakh by this end month end, I'll make the payment of 25 that I'm supposed to make. Then that particular person gives promise to the other person. So there is a chain of promises based on your own promise. And if you commit breach of contract, the whole chain is damaged. Everybody's promise in further will not be fulfilled. They will not be able to fulfill because this was based on this. Now, at all, I say that I am going to Delhi for for an interview. If I get that particular pass in that interview, then the employer is going to get his daughter married to me, and then I am going to get his entire business. Is my plan. And the Air India cancels its flight from Pune to Delhi. In that case, can I sue Air India for airfare? Then my loss of, I could not marry that particular girl, and then I could not get the business of her father. All these things, totaling an amount of 50 crore I want. Can I sue, make up demands 50 crores from the airliner? The answer is no. And therefore the rule for that, how much is the liability, how long the liability you can stretch, how much is the liability, that particular liability, the rule pertaining to that was settled in Hadley versus Bexendale in England, wherein it says that the rule, simple rule is that the natural consequences of the breach should be considered. The natural consequences of the breach should be considered and nothing beyond that. Now, what are the natural consequences? If at all I could not go to Delhi and attend that interview, then the airfare I am entitled to get and compensation probably of some few rupees I will get, few thousand rupees I'll get, not beyond that. That I was supposed to get married to that employer and that get his business. Nothing will be considered. Natural consequence has to be taken into account while quantifying the damages. Now, in a contract itself, you may put condition of penalty and you may put clause pertaining to liquidated damages. Penalty is that you shall cause construction of my flat within a period of 24 months. Within a period of 2 years, you have to give me flat. If you don't do that, per month, you shall be liable to pay me 50,000 rupees. So that is the cost. That is punitive cost. That is a fine. That you will be paying me 50,000. So complete it in 2 years, give it to me. There is no question of payment of cost. But if you delay the delivery of flat by 2 months, 3 months, then in that case, accordingly you will have to pay. So that may be written in the agreement itself. Second is liquidated damages. Liquidated damages are damages which are quantified in the contract itself. They are named in the contract. They are mentioned in the contract that if you commit a breach of contract, you will be liable to pay liquidated damage of 2 crores. If I commit a breach of contract, I will be liable to pay 2 crores. So that is liquidated damages. And in case of breach of contract, if the matter goes to the court is duty bound to pay the liquidated damages. Why? Because they are named in the contract you have agreed. Once you have agreed, you have to pay for it. So that is the law in respect of liquidated damages cost, and this might be mentioned in the agreement itself. As far as liquidated damages, penalty clause, all these must be mentioned in the agreement while you execute the agreement. When there is a offer, acceptance and promise, at that time only these things should be discussed. If at all you are able to prove that from the very beginning we had intentions of payment of liquidated damage and all that, then in that case those will be returned to be, that will be directed to be returned to you, paid to you. Then there is a concept called, now as far as breach of contract is concerned, again, if I offer to perform my part of the contract and the other party refuses to accept the performance, I am absolved from performing my part of the promise. I am absolved. I need not perform. I have to send one letter that my 100 mobiles are ready. When should I deliver them? She does not respond. My responsibility is over. So when the offerer makes a payment, rather makes an offer to perform, and the other party does not respond, the liability of the person who makes the offer comes to an end. There is no breach of contract on my part. Understood? So this is another aspect as far as breach of contract is concerned. Then there are contract of guarantee. If you have heard, guarantee In guarantee, there is a surety, principal debtor, and the creditor. In guarantee, there is a principal debtor who is a borrower. I go to the bank, I borrow money from State Bank of India, I borrow 5 crore rupees from the State Bank of India. I am the borrower, this is principal debtor. The, the creditor is State Bank of India, and the third person is surety. Surety is the guarantor. In common parlance, we call him as the guarantor. The surety agreement is to this effect that if the principal debtor fails to adhere to his promise, then I shall make the payment. So if the principal debtor, if at all I am borrowing 5 crores from the bank, if I fail to make the payment to State Bank of India, she remains as a guarantor, saying that if Mr. Kulkarni fails to pay, I will make the payment. This is exactly what is called as she is surety, I am the principal debtor, and the bank is the creditor. So this is a tripartite agreement, mind well, tripartite agreement, and there might be 1 or 2 or 3 sureties. Now this is in respect of money. The guarantee might be in respect of borrowing money when it involves some certain sums. There might be guarantee in respect of performance, and this is exactly what is called as performance guarantee, saying that I have taken a contract of constructing the whole factory premises. I may give a performance guarantee to the person who wants to construct that particular factory, saying that if I fail to perform, you may invoke this guarantee, and this guarantee is of 10 crore. So this guarantee is of 10 crore. The bank will give the guarantee, saying that if Mr. Kulkarni fails to construct the factory, then if he fails to perform, then he is supposed to, rather the bank will pay that particular person 10 crore rupees, because that is the value mentioned in the guarantee. So there is a guarantee in respect of repayment of payment, and there is a performance guarantee. Both these guarantees can be executed if the contract is not performed, if there is a breach of contract. Now there is a third kind which is called as a continuing guarantee. Continuing guarantee is in respect of series of transactions. So first consignment is supply of 10,000 mobile phones. The second consignment is delivery of 5,000 mobile phones. The third consignment is delivery of 15,000 mobile phones. So series of transactions. In that case, I may remain as a guarantor for all the continuing transactions. This continuing guarantee may be stopped by giving notice. So in the third transaction itself, I may say that you are not performing properly, I want to revoke the guarantee. So by giving notice, such guarantee can be terminated. Now, if the guarantor makes the payment, meaning thereby I am the borrower, she is the guarantor, I fail to pay, and therefore she makes the payment, the guarantor is entitled to get money recovered from me. So the guarantor subsequently can sue the principal borrower and recover that entire money. There might be co-surety, and in respect of co-sureties, their guarantee, rather surety, should continue together, and they are equally liable to pay. That's what the Indian Contract Act says, unless there is a specific bifurcation from this. So they are equally liable to pay. And then comes bailment. Now, contract of bailment, a contract of bailment is a contract wherein one person delivers goods. So what is important is goods is obviously movable property. When one person delivers goods to the other person for a particular purpose, and after that particular purpose or object is achieved, the person giving that particular good or article is entitled to get it back. Is a contract of bailment. The person who gives the goods is called as bailer, and the person to whom the goods are given is called as bailee. If at all I go to a cycle shop and take a cycle on rental basis, I pay him 100 rupees, he gives me cycle for 1 hour, I ride the bicycle for 1 hour, and I return the bicycle to him. This is a classic example of bailment, wherein he is the bailer, I am the bailee, I am supposed to take care of the bicycle and return the bicycle in the same condition to the bailer. So there are many such things wherein delivery of possession is most important. The person to whom such delivery is given is supposed to take care of those goods, and the bailee is supposed to return the goods to the bailer the moment the purpose is achieved. So there might be some purpose, and that purpose, if at all is achieved, then you are supposed to, thank you, then you are supposed to return the goods. Another example is I go to a goldsmith, give him the gold, and I ask him to make a ring. He prepares a ring and gives me the ring. So my gold was given to him. He has converted it into a ring, and I'm getting the ring. This is a contract of bailment. So delivery of possession is most important. Now the bailee is not supposed to make unauthorized use of the good bailed, meaning that if at all I have taken a bicycle, I cannot ride it with rather make it ride 4 persons sitting on the bicycle. So that is unauthorized, and therefore such kind of unauthorized use is illegal in binding law. If at all there are goods of mine and the other goods have been bailed to me, I mix them with my own goods. The mixture, if at all, can be separated. It can be separated at all. Then it cannot be separated. In that case, those goods can be rather I am entitled to get the cost in proportion to that particular mixture. So produce. So the mixture जर केलेलं असेल तर that mixture प्रमाणे त्याची cost आम्हाला मिळण्याचा अधिकार आहे. Then if at all the bailee has incurred any expenses on again maintenance of those goods, the bailer is supposed to make the expenses good. So किती वेळ आहे अजून मला बोलायचं? No, it may so happen that the goods have been bailed to me, and the person giving the goods may not be the real owner of the property. And the third person may come and say that this particular mobile is not his, this particular mobile is mine. So the third person is claiming the goods. In that case, he has to go to the court and get a stay, get an injunction that the bailee is in possession of the goods. These goods are mine. This is the proof, and the bailee should be restrained from delivering the goods to the bailer. Such kind of injunction can be sought from the court. Then the finder of the goods, he is also in the same position. He is in the position of the bailee. Same terms and conditions are applicable to the finder of the goods. The bailee has a lien over the goods so bailed. Lien meaning that he is entitled to retain those goods unless until his expenses are not paid. I go to the watchmaker and give him the watch for repair, and the repair charges are 700 rupees. I say that I will not pay. The watchmaker is entitled to keep this watch. He has a lien on this watch until I pay him 700 rupees. So this is bailee's lien. And there is a contract that says that even the attorneys and bankers, they have a lien on the documents which are in possession of them. That's what the Indian Contract Act says. However, there is a judgment of Justice Thomas, Supreme Court, which says that for non-payment of client's fees, the advocate cannot retain. He has no right of lien over the advocate's documents. The advocate's documents must be the client's documents. The client's documents must be returned even if the client has not paid you the fees. Is the judgment of the Supreme Court on lien of the bailee on bailer's documents. So Contract Act says, but the Supreme Court interpretation is totally different, and the further Supreme Court's judgment says that the advocate can sue the client for recovery of professional fees. So I have to sue the client in that case. So that is the judgment. Now pledge is again a bailment. The object is to secure the debt. So if at all I go to the goldsmith and say that this is my ring and I am keeping this ring with you and pay me 50,000 rupees. He pays me 50,000 rupees. I use 50,000 rupees. I go back to him, pay back 50,000, 10,000 interest. He has to return it to me. The object of pledging that particular good is to secure the payment. So this is essentially a contract of bailment, but the object is to secure the payment. And basically, I am entitled to redeem that particular thing pledged after I make the payment. So after I make the payment and interest, the bailee has to return the goods. If at all he does not, then in that case I am entitled to go to court and regain those goods from him. Last topic is agency contract. Now agency contract is again, one person employs the other person, gives him the authority to act on behalf of him. So this is exactly what is called as contract of agency. The agent, person who has been appointed as to work for him, is called as an agent. The person who gives this authority is called as a principal. It is not necessary, mind well, for each and every agency contract there must be consideration. So this is again an exception. For each and every contract of agency, it is not necessary to have consideration. The authority that is delegated to the agent may be expressed or it may be employed. It may be implied. And last and most important thing is that even if the person has no authority, he has not been given express authority, however, he acts on behalf of that particular person. And subsequently, the principal ratifies that act. He said that, okay, if at all you have sold this particular property, I am agreeing for this consideration, I will also execute the sale deed. He ratifies it. In that case, that ratification will also serve the purpose. Termination of agency can be done by giving notice by one party to the other. Principal may give notice of termination to the agent, or agent may give notice of termination to the principal. Now, what is important and last important thing is, as far as you advocates are concerned, what makes power attorney? Power attorney essentially is a agency contract minded. Power of attorney, Kul Mukhtar Patra, is essentially an agency contract. What makes it irrevocable agency? इरेवोकेबल पॉवर अटॉर्नी मी से आपण म्हणतो कधीही रद्द न होणारे कुलमुखत्यार पत्र. ते का होतं तर याच फक्त एका कारणासाठी होतं, whenever agent's interest is created in the subject matter of the agency contract, such agency cannot be terminated. It cannot be terminated. Agent's interest is created. Classic example of this is builder. When the landlord gives him the power attorney, builder, he pays him 5 crores. And the landlord gives the builder power attorney to cause construction. Such kind of a power attorney becomes irrevocable. Why? Because agents, builders, right is created in the agency contract. Because he has paid me 5 crore rupees, I cannot subsequently revoke it. It becomes irrevocable. So I think I have covered everything right from offer till agency. If at all you have any questions, you are at a liberty to raise the questions. Okay. Now you will be given objective questions, I think. The questions are objective. So 1, 2, 3, 4. So if at all you are able to ascertain the answer properly, because there is a negative marking also. So if at all you write wrong answer, your rather marks will be reduced. In that case, first see the entire paper and think what questions you can write properly. Those questions should be written first. The things about which you are not certain, you should not attempt those questions. And if at all you are not able to answer, don't worry. Don't think that this is a very difficult paper, I will not be able to write it properly, so I should not write the paper at all, or don't get nervous. Jot down the things, write it properly, and it's very easy. Basically, there are too many questions, and concentrate on certain subjects. For example, you have CPC, you have Contract Act, you have CRPC, you have IPC. So for CPC, how much weightage you should give? For contract, if at all I have taught you contract may be of about 7 to 8 marks or 10 marks. CPC might be of 30 or 40 marks. So major laws like CPC or CRPC you should concentrate. Contract and specific relief and Sale of Goods Act and Partnership Act, commercial enactments, all these enactments you should know, but concentrate on major subjects like CPC and CRPC and IPC, because most of the questions being judges examination will be on procedure. Obviously, no doubt, substantive law will be asked, but procedural law will be examined in these question papers.
कोणाला काही क्वेश्चन सरांना विचारायचे असतील, काही क्वेरी असतील तर आपण विचारू शकता.
Thank you so much for patient hearing.
धन्यवाद सर. आपण कॉन्ट्रॅक्ट ऍक्ट व त्यातील सगळे जे काही संदर्भ आहेत याचा आपला अमूल्य असे मार्गदर्शन आम्हाला केलेलं आहे. त्याचा नक्कीच फायदा परीक्षार्थींना भविष्यात होईल. आपण केलेल्या मार्गदर्शनाबद्दल पुणे बार असोसिएशन अध्यक्ष व संपूर्ण कार्यकारिणी आपले आभारी आहे. सर्व परीक्षार्थींना कळवण्यात येत आहे की उद्या ऍडव्होकेट राजेश कातोरे सर यांचे देखील लेक्चर आहे दुपारी 1 वाजता. तरी आपण सर्वांनी आवर्जून उपस्थित राहावे. तसेच दिनांक 1 मे 2026 रोजी आपण सर्व महाराष्ट्र दिन साजरा करीत असताना माणुसकीचा काळीमा फासणारी घटना पुणे जिल्ह्यातील बोर या ठिकाणी घडलेली आहे. सदर घटनेचा पुणे बार असोसिएशन कडून जाहीर निषेध करण्यात येत आहे व सदर आरोपीचे कोणीही वकीलपत्र घेण्यात येऊ नये याबाबत पुणे बार असोसिएशनने एकमुखाने ठराव पास करण्यात आलेला आहे. धन्यवाद. शिंदेगड शिवसेना पुणे यांच्या वतीने नसरापूर येथील प्रकरणामध्ये पुणे बार असोसिएशनला निवेदन देण्यात येत आहे. आपणाला नक्कीच आश्वासित करू इच्छितो की पुणे बार असोसिएशनने या संदर्भात ऑलरेडी ठराव पास केलेला आहे की जेणेकरून सदर आरोपीचे कोणीही वकीलपत्र घेण्यात येऊ नये या संदर्भात.